My name is Ryan Dyer. I'm one of the attorneys here at Beresford Booth in the litigation group. And today for our weekly webinar, I'm going to give a short presentation on civil discovery. The presentation is going to be definitely more elemental and geared towards non-lawyers, although anyone might find it somewhat helpful. And my kind of purpose here is just to give just help kind of define some terms, describe what civil discovery is, the different parts of it, and how clients or prospective clients can be prepared for that and what to expect. So let's get right into it. So what is civil discovery? Civil discovery is essentially the formal process by which parties in a lawsuit can request and obtain information relevant to their claims, defenses, or counterclaims in that lawsuit. A good analogy would be like in a criminal context, it's similar to the powers of law enforcement to investigate, and also similar to the rights that a defendant would have to gather evidence in their own defense. Same concept in a civil lawsuit, which is what civil discovery is. Now, the scope of civil discovery is quite broad, and under the rules of civil procedure, which apply to all the parties in a lawsuit, civil discovery allows a party to obtain information on, quote, any matter not privileged which is relevant to the subject matter involved in the pending action. Just to give some sense for how broad this is, this means that you cannot object to a request for information based on the grounds that the information sought would not be admissible at trial. The standard is whether the information sought could lead to the discovery of admissible evidence. So kind of the bottom line here is that a court in a civil case is going to usually look upon a party's civil discovery request pretty broadly and will let them seek discovery on a lot of matters. Now, an important thing to remember here is that by being a party in a civil lawsuit, regardless of whether you're the plaintiff or the defendant, you have an obligation to respond to civil discovery as long as it falls within the scopes of allowable discovery. So that's something to definitely keep in mind if choosing to initiate a lawsuit or to somehow become involved in one, is that you will have an obligation to respond to civil discovery. And if not, there could be pretty severe consequences, which we'll get into later. But let's start before then. I think a lot of times, especially for clients or prospective clients, there can be very helpful forms of informal discovery, essentially, that can really aid your case. And kind of four of the main topics that I just want to outline for folks is there's the public records request system. And now in Washington State, where we are, it's a pretty robust system, and it covers state, county, municipal, and other local government forms. Basically, any sort of state or lower level government agency is required to respond to public records requests. And the system is pretty robust here when compared to some other states. So when thinking about your case, it might be helpful to think, are there any public records out there that might be relevant to what's going on in my case? And if so, maybe I should request them. A couple other sources would be public archives, libraries, and just court records, all of which are available typically online and definitely to the public in general. So that's something to think about is your case is starting and you're seeking to consult with an attorney or anyone else, is whether there's a way for you to get a hold of documents on your own and bring those to your initial consultation with an attorney about your case. Now, things especially for clients or prospective clients to think about is some pre-litigation discovery considerations. The first one is the documents and information you yourself might already possess. Whether that's a contract, a real estate contract, text messages, emails, letters, billing statements, photographs or videos, anything that's really relevant to the legal issue that you're facing. You should take an effort to secure that, to save it, to back it up, and just to make sure it's secure so that it can be used at a later stage. I'll get into this more, but a big issue over the last 20 years has been social media. And so right off the bat, if individuals are involved in something that they think might turn into a lawsuit, it's always a good idea to go and make sure all your social media accounts are set to private, meaning that only people who you have accepted as a friend can view that information. It's also a good idea to go through and audit your friends. Sometimes there can be fake accounts, or catfishing is another term used, where people will set up a fake account and a lot of people will just accept that friend request, and then that person, whomever it may be, has access to all your information. One thing to be very wary of is in a lot of cases, there might be folks who think that there's a certain document or contract or other piece of information that's not helpful to them. Let me just say that usually it does not. Usually trying to hide or destroy documents that might be unhelpful will have serious repercussions, especially in the digital age. It's impossible to ensure that all documents are accounted for and all copies of them have been gotten a hold of. If that's done and a court finds out about it, there will be serious consequences for the party. So, and that's called spoliation. And so as a general practice, it does not pay in any way to think about hiding things. It's better for you and your attorneys to know about all the documents that exist out there and to deal with the facts as they come, as opposed to any other method. So long story short, when it comes to pre-litigation, make sure you gather everything and back it up. Make sure your social media is set to private, and we'll get into that a little bit later. So now I'd like to just outline for folks what the types of civil discovery are. The first one is, they're called interrogatories, and that's basically just an antiquated word that describes questions, written questions that the parties can send to each other formally. Now, a lot of times this is the least interesting part of the civil discovery process, but it can be very, very helpful. The types of questions and the number of written questions or interrogatories that a party can propound or serve on another party and require them to answer is limited and set forth in local court rules. Some examples of how interrogatories are used is, for example, you could say, please identify anyone by name and address and contact information who has information about whatever the given legal dispute is about. So whether that's a contract, a car accident, a construction project, a business deal, whatever it may be, you can use interrogatories to get information like witnesses, locations, and sources. So for example, you could ask a company who you're having a legal dispute with about where they store all their documents related to the transaction that you had with them. And that can be a good example of how you can use written interrogatories or how they can be used by another party as well. The second major type of civil discovery is called request for production. And basically that covers, that defines your ability to obtain documents and many other sources of communication or any sort of medium. For example, photographs, videos, audio recordings, all those things can be requested through what's called a request for production. Once again, the party who's making the request has certain limits that it has to be what's called discoverable, meaning it has to have a reasonable likelihood of leading to the discovery of admissible evidence. But a request for production is the method for obtaining those sorts of documents and other things. Admission. Another one that doesn't get talked about a lot is what's called a request for admission. And that's basically asking someone, asking another party to admit or deny a yes or no proposition. So a good one, for example, would be, admit or deny whether you were at such and such a location on such and such a date. Usually the other party will either admit, deny, or raise an objection to that. Now, these can be very helpful to narrowing the issues, confirming or denying basic facts, claims, and procedures, and to pinpoint what the contested issues in the case really are. So a lot of times you'll hear your attorney talk about issuing requests for admission. That's what they're referring to. Another type of civil discovery, which does fall under the other rules, but kind of deserves to be broken out, is called the inspection of property and tangible things. So for example, if you're in a property dispute with a neighbor or something like that, there's actually a way that you can request and the court will enforce your ability to go onto that property with a certain protocol to inspect it if it's relevant to your lawsuit. Another important thing to remember is the inspection of property and tangible things, especially in the digital age, can apply to electronic devices like computers, smartphones, servers even, or any other sort of digital storage device. The kind of more old school thing would be being able to go into a company and actually inspect their files and their archives. So that's something to be wary of on both sides of it, but something definitely to be aware of is that there is the ability to actually come and physically inspect a computer system in the context of civil discovery. One thing that many lawyers are aware of, but might be worth pointing out too, is that discovery also lets you take discovery about discovery itself. And I know that's somewhat of a circular topic. Basically, the idea is that you can actually propound and receive discovery asking you to outline all the places you looked or all the places an opposing party looked to come up with responsive documents. This can be very helpful if there's an insinuation or suggestion that a party is not producing all the documents they actually have or is hiding something. They could be subject to discovery from another party to actually ferret out all the places the documents may be and to confirm whether or not that party has actually exhausted those sources of information. Another big part of civil discovery, and one that people might be more familiar with, is what's called a deposition. A deposition is essentially a question and answer format where attorneys typically for the other parties get to ask a witness or an individual questions. This is very important because essentially what it does is it lets the parties understand what a given person's testimony would be if they were ever called to trial. Now, another thing to remember is that if the case ever does proceed to trial, your deposition testimony, if it was taken previously, can and will be used against you at trial. So if you testify something during your deposition, it's going to be pretty difficult to maintain your credibility if that testimony changes at trial. Same thing goes for the other parties in the litigation. So a lot of times you'll hear attorneys talk about how identifying who the potential witnesses are for future depositions. And that's something to be prepared for yourself if you ever find yourself involved in civil litigation. Now, so far we've talked about the sorts of discovery that can happen between the parties in the lawsuit. So the plaintiffs, the defendants, the counter defendants, and so forth. Of course, there's going to be a lot of situations where relevant information or testimony is not going to be given by the actual parties to the lawsuit. In other words, it's going to be information or testimony that is kept or known to non-parties or third parties. The way that information can is gotten in the civil discovery process is through subpoenas. Now, basically, subpoenas can be used to do pretty much most of the things that you could do with a party. For example, you can do interrogatories, you can ask for the production of documents through subpoenas, and you can take depositions of third parties through the subpoena process. Now, while the subpoena process is pretty similar to the civil discovery between parties, there are some limitations that the court is more willing to give. I think the policy underlying that is that the courts will acknowledge that, look, this is a third party. They're not really caught up in this lawsuit in terms of not being a party themselves. So, we don't want the burden on them to have to produce documents or people to be as high. And so if a court feels like a party is overburdening a non-party with civil discovery, there could be ways for that party to protect itself. And the court might enter protective orders limiting how much information or burden can be imposed on that third party, but the subpoenas generally describe that process. Now, as I stated at the beginning, and I put it here, and I apologize for some of the cursing in this, but I wanted to demonstrate this. It's very important for potential parties who think they're headed towards a civil lawsuit to really clamp down on their social media and to be very wary about that. Especially in today's day and age, courts will usually let social media come in as long as it's somewhat relevant to the case, and that can have pretty drastic consequences. A lot of folks communicate with their friends or family on social media. A lot of people will vent their frustrations, especially with litigation on social media. And if that is open or obtainable by another party, you can expect it to be used against you. In this case, I put a little slide in here to show you where there was a couple people going back and forth about a lawsuit and about what an individual's motivations were with that lawsuit. As you can tell just from the highlighted parts, that's not going to look very good in court if that gets introduced, showing that person had, well, basically was in this frame of mind. I think you see reference to drugs, to they're only motivated by money, things like that. So definitely, if you think you're headed towards a lawsuit, take very, very careful steps to make sure your social media is protected and set to private. Now, if just as a heads up, a lot of times there can be disagreements between the parties and their attorneys in civil discovery. There's usually 4 ways that kind of sorts itself out. Typically, the attorneys are required to meet with each other and confer and try to find a solution to the objections or to what's happening. If that doesn't happen, a party can always go to the court and seek what's called a protective order, basically asking the court to strike another party's requests for civil discovery and to protect that party from those burdens. On the flip side, a party who feels like the person or the other party whom they've asked civil discovery for and has not given it doesn't have a valid basis for not doing so, they can go to the court and ask for what's called an order compelling the discovery, and that's done through a motion to compel. Basically, the court will say, yes, you need to produce these documents, or you need to produce this person for a deposition. And if you fail to do so, then the court might award sanctions. And those can be pretty severe, up to including the court actually entering a default in favor of one party or the other. So these are kind of the protections and enforcement methods for civil discovery to be aware of. That's really all I have. I just wanted to give, like I said, a brief overview. If you have any questions or you think you have a dispute that might be headed towards litigation, it's always good to seek the advice of an attorney at the outset to make sure you're protected. And usually you will get you will receive advice about how to prepare for the civil discovery process that's sure to follow. So unless anyone has any questions, I will go ahead and end it there, and you can contact me anytime, and I'd be happy to consult with you about your problem. So thanks. My name once again is Ryan J.P. Dyer on behalf of Beresford Booth, and I hope this was helpful to folks.